A very good evening and welcome to ANN7 Prime this Sunday. My name is Lauren Janae. It's just gone past 6 p.m. Let's get straight into the top story that we're following at this hour. The National Prosecuting Authority has given the President until the end of November to make representations on why the 783 charges against him should not be reinstated. This after the Supreme Court of Appeal upheld a High Court ruling that the decision to withdraw the 783 charges against Zuma was irrational. But the judgment by the Supreme Court in Bloemfontein in dismissing an appeal application by the NPA and President Jacob Zuma has brought about some key constitutional and legal principles in the spotlight, including the prosecutorial independence of the NPA. For now, President Zuma has to submit any envisaged representations to the NDPP before November the 30th. Opposition Democratic Alliance has also been invited to submit further representations in the event they deem it necessary. And finally, investigating officers in the case have to assess the availability of witnesses and any factors which may impact the feasibility of re-enrollment of the matter. And to further discuss this, we are joined by our live panelists here coming live from Midrand. Thank you so much for joining us. We're joined by Setagi Khomo, who is a political and legal consultant. We're also joined by Tsebo Kadima, who's a political analyst live in studio. Thank you so much for your time here. We appreciate you being here. Setagi Khomo, let's first talk to you. You came out with an article which basically talks about this and basically what our debate surrounds. It came out in the Sunday Independent titled "Why the NPA Should Not Prosecute President Jacob Zuma." Can you please elaborate on why it would not be in the best interest of the administration to prosecute him?
Well, one would have to look at the constitutional right of every citizen in South Africa. And that also, those rights that are enshrined in Chapter 2, which is Bill of Rights, also extend to any person who is holding any position in government, including President Zuma. Now, if you look at the whole situation regarding the so-called spy tape matter, this matter has been dragging for a very, very long time, to an extent that one asks oneself as to whether at any point in time one can say a fair and speedy trial will take place. If you look back, President Zuma had been living from 2005 under a cloud of these so-called charges, 783 charges as they are now being called. So in terms of Section 35(3)(c) of the Constitution, it clearly sets out and imposes duty on the prosecution authorities that they should, any person accused should be afforded a fair and speedy trial. From 2005 to date, can you really say that President Zuma had enjoyed that? I would like to say that my paper is saying, the paper that you are referring to that has now been published, is arguing that he has suffered prejudice. If you look at also far back, the then Director of Public Prosecution, Bulelani Ngcuka, went public and said they had, as the NPA, prima facie case, but is not winnable against Zuma. That already, that statement is prejudicial, because it means that somebody remains accused, but we cannot be able to prosecute. Now, furthermore then, when the charges were brought in, there's been several requests to the court in Pietermaritzburg to say that the NPA was not ready. It was about 2 times that they had requested that. The judge president of the division in Natal, Judge Shabalala, said no. They then struck them off the roll. So until then, there was that decision by NPA to actually drop those charges based on the developments around the so-called spy tapes. The point I'm trying to make in that article is that no person should be treated the way in which President Zuma has been treated, to actually be subjected in a very cruel and atrocious process in which you never actually enjoyed closure at all. From 2005 to date, it is a very long time. Section 35(3)(c) of the Constitution says the right of every accused person is a fair and speedy trial. That's what I'm saying. And having also said that, I'm referring in that article also on some authorities. One authority is the Seriti Commission of Inquiry, which inquired into the allegations of corruption and so on and so forth in the so-called arms deal. And the conclusion of that commission was clear that there was no evidence, no finding whatsoever of any form of corruption at government level among government leaders. Zuma was part of the government at the time, by the way. And interestingly and fascinatingly, Shabir Shaikh, who actually was charged and convicted of corruption charges emerging allegedly from the activities of the arms deal. That was also used, the conviction of Shabir Shaikh was used to get rid of President Zuma. That was on the 22nd of May 2005 when he was fired by the then President Mbeki. All this period, I would like to argue, and I continue to argue, that that amounted to prejudice on any individual and therefore infringement of the Section 35(3)(c) rights.
Mr. Kadima, do you share the same sentiment? Do you believe that President Jacob Zuma has not received a speedy and fair trial and his constitutional rights have been violated since 2005?
Most certainly, and that is based upon empirical evidence as adduced in terms of the various cases that have been referred to. And what Mr. Homo is referring to in terms of Section 35(3)(c), I just cannot see how conceivably the National Prosecuting Authority can even get out of the starting blocks in attempting to prosecute a case which in any case has been found not only by the or not only alleged but having been found even by the former public protector Lawrence Mushwana, Advocate Lawrence Mushwana, who made a finding that was neither reviewed or set aside in a court of law. Last year, 2016's Nkandla judgment in the Constitutional Court, rather, if anything, was absolute clarity that we required. And on the basis of the Constitutional Court ruling as far as the powers of the public protector go, and as far as that the findings of the public protector, unless reviewed or set aside, are binding, therefore the National Prosecuting Authority today, they are in that position which they cannot even get out of, that prejudice, immense prejudice has been suffered by the president. And in fact, if anything, the other point that Mr. Homo has made in his article, which I agree with wholeheartedly, that when they chose to try Mr. Zuma in the court of public opinion, they effectively brought upon, in the prejudice that resulted thereof, they brought about the double jeopardy legal principle, which he so eloquently raises, that effectively here, if they were to attempt to charge him now, they will be now retrying him for exactly the same case that, by the way, he's already suffered for without having ever been convicted. And also the National Prosecuting Authority, bearing in mind, as I say, case law already is there. Twice, the matter was thrown out of court. The indictment, which the mainstream media has for a long time been running with this advertorial that there are 783 charges, which is egregious mischief, even by the part of the opposition, being the Democratic Alliance in this case. Effectively, the indictment that has never been able to see the light of day, which was attempted, was on 3 charges, 18 counts, and then 783 different transactions which were put together, wait for it, by none other than KPMG, who have today been found to have not been a reliable firm that by their own account. So again, when you say, well, those 3 charges and the 18 counts, they are not able to stand because of the evidence which was never ready. The National Prosecuting Authority has never once explained what materially changed in terms of the body of evidence which on the case that was thrown out, to the extent that they can now say that they are ready to prosecute. Because if they were not ready to prosecute then, which resulted in the case being thrown out, unless something fundamentally changed in their case, and they've never been able to prove that, it is impossible. And of course, the Seriti Commission, if anything, sealed this trial, which had never been. And Mr. Nguka, by the way, what was argued, and in terms of the Supreme Court of Appeal, we are thankful that, as South Africans, that they have provided clarity once and for all, that the decisions and the power of prosecution lie with the National Prosecuting Authority and no other organ of state. That being the case, it has never been, therefore, been explained as to the conduct of Mr. McCarthy, which has never been denied in terms of the spy tapes. Nobody has ever adduced any evidence to doubt the authenticity or that they are not the veracity of those spy tapes. So the spy tapes, for all that we know, unless and until such time that there is rebuttal, they stand as evidence. And therefore, it speaks to what? The egregious power, abuse of power. It has been abuse of power, not abuse of process. Therefore, when Mr. Zuma makes his representations, I think the time couldn't have been much more better now. He's got a trade wind that really, it means that he's going to be in the clear. It will not be possible for the National Prosecuting Authority to ever be able to prosecute a case, and more so on the constitutional grounds, which they cannot get out of the starting blocks from.
Let's talk about the Democratic Alliance and their letter to Sean Abrahams to reinstate these charges. Is this not putting political pressure on the NPA? Is this what we're seeing? Let's start with you.
Well, for a long time, I mean, and this is appalling conduct by the Democratic Alliance, who have, at whenever time, those who care to listen, they like to protest about the need to maintain the independence of specifically Chapter 9 institutions or even Chapter 8 institutions, and that the rule of law should apply at all material times. Therefore, ordinarily one would have expected that they should have appreciated the need for the independence of the National Prosecuting Authority, that whenever they prosecute any case whatsoever, there should never be any, they should not do so to do a favor to anybody or to prejudice the rights of any citizen or out of fear of anything from anybody. So therefore, their tactics and antics can only be seen as an act of intimidation of a constitutional structure such as the National Prosecuting Authority. And as South Africans, we should be dismayed at the conduct of this political party, that they should desist from that. Because if the Constitution is to become alive for all, then institutions such as the National Prosecuting Authority, established under the rule of law, which is our Constitution, they have to be respected and not in any shape or form be subjected to any form of pressure or persuasion, as the case has been.
Mr. Khomo, let's turn lastly to you. Let's talk about the readiness of the NPA in order to prosecute President Zuma, as you mentioned in your article. It's been 10 years of failure by the state to prosecute and finalize a case against him. Is the NPA ready to prosecute now, as Mr. Kadima did say that something fundamental needs to change in order to prosecute him? What are your thoughts?
Well, the mere fact that the former National Director of Public Prosecution, Bulelani Nguka, uttered those words that we have got a prima facie case but not winnable case. That tells you something. That says that here we are dealing with a very difficult situation. The mere fact that on more than one occasion they had to ask the Pietermaritzburg High Court that they are not ready, the NPA was not ready to prosecute, tells you something. The mere fact that that National Director of Public Prosecution said there is prima facie evidence but not winnable, it tells you that there is no case. And even at this stage, the article that I wrote questions the readiness of the NPA as of now. In terms of evidence, in terms of whoever they would use, they would like to use as witnesses, etc. The case itself seems to be stale, so to speak, if ever there was a case. But the most important thing here is the prejudice that has been suffered. And I would like to also even say that that underlines either the refusal, unwillingness, or inability of the NPA itself to be able to have managed this particular matter. In law, we talk about case management. When you receive, if you are an NPA, you receive from the investigators a file. Then that file then goes into a case management. Then you assess as to whether this is the case that you have to actually expend state resources into. I don't believe that they had reached any point, given what Ngcuka had actually told the public. In fact, Ngcuka had thought he had told the editors, but then that statement went public, and then it was published, and that's what he was saying, that the NPA would not be able to have a winnable case. Even now, Sean Abraham's way he stands now, if he was to now say, Mr. President, you are now going to be the accused, the big question is, can they be able to sustain a case that can actually be standing on the 2 feet? I doubt that.
Well, that's great. Unfortunately, we do have to end it there, but a great comment to end off with. Mr. Khomo, Mr. Khadima, thank you so much for your time here. We really do appreciate it. Very interesting article, an interesting read indeed. Time now for other